Who supersedes if there's a co-trustee and there's a genuine issue of disagreement?
If you can't get along with somebody who's your co-trustee, somebody's going to have to either agree, these two parties are going to have to agree in some fashion, or one person's going to have to step aside.
Okay.
And Peter, I thought that was a really good discussion, because you can have situations where a co-trustee works, and you can have situations where, depending on the personality and the type of assets and the function and the beneficiary is named, a trust protector, someone who is there to take over certain functions, may work better.
Yeah, if you think of it, the problem a lot of times is that you name a family member and they think they may have to do everything themselves. What they ought to be doing is thinking about it as a CEO. They don't have to sell the house, but they have to make sure that they hire the correct individual to sell the house. They don't have to do the tax return, but make sure that they don't hire H&R Block to do a 706 return, okay? Make sure that they have somebody and hire somebody competent to handle the last tax return, who's used to doing fiduciary work. If the house needs to be fixed up to be put on the market, do they know and hire good contractors who can fix up the house in a decent amount of time to get it on the market? So, from my point of view, the trustee is more like a CEO. I am only as good as my network. Gary, you rely on all your network, correct, as far as Northern Trust is concerned in getting things done, besides the fact of additional staff.
See, and this is important, because the thought would be, gee, we're Northern Trust, we can do so many things, we don't need anybody. That couldn't be further from the truth. When we step in as successor trustee, I want to know who the CPA, I want to get together with the CPA who has worked with this family for 20 years and knows where everything and how things have been done. I want to get together with the business manager, the life insurance agent, whatever professional, the attorney, whatever professional team that helped this person during their lifetime, or this family. You're best off to keep that team together unless there's a reason not to. So you got, and that can be a problem sometimes for someone who's an individual. Say you have 3 children and you appoint your oldest son because that's the honor bestowed on your oldest son. And the first thing he or she might do is say, gee, I really don't want to spend too much money. I think I can save a little bit on the accountant or the attorney, or not call these people quite so often. That is a big mistake. Also, Peter.
Yes.
I have 3 kids, and I want to appoint my son as the trustee, but I'm afraid his brother and sister won't be quite so happy. So I think what I'm going to do is appoint all 3 of them as co-trustees.
Yeah, an absolute disaster.
But that way they can all work it out.
Yeah. The thing of it is when you name 3 people, or even when you name 2 people, you go to the financial institution to marshal the asset. What are they going to want to see? They're going to want to see everybody's driver's license. They want to get everybody's signature, and they want to make sure that all 3 are cooperating. Because if they hand the monies over to the 3 trustees and there's a problem, the bank or the financial institution may be held liable. And so, I've seen it work out. By the way, 80%, I'm talking for most everyone, no matter how awful your document is written, no matter how bad your family is, it always seems to work out. I don't want this to become a session where we're putting the fear of God in you and that you have to hire Gary and Northern Trust. You do have to hire me, but okay? But most things work out. And I don't want you to come out of here this session thinking that there's going to be a problem. But if you know that there's going to be a problem, deal with it now instead of later.
Should you tell your successor trustee how much money you have?
You know, I would give them somewhat of a ballpark as to the successor trustee, but I would not get into the details. It's one of the reasons why we named the program It's Your Estate. Maybe we should have put a little thing underneath that said, not your children's yet. Okay?
Or maybe
You're
ever.
in control. Okay, and make sure you stay in control. You'll live longer, you'll be happier if you're in control. So if you think that you have a bully son or daughter who's going to try to take control, then don't let them know anything. On the other hand, if you think that there's a person there that you can speak with, the more they know about your estate, the better off they're going to be. But it's each individual family's decision.
Honey, I never did trust your brother.
Do you want to go out for a drink after? If you're going to name a child or whomever, think of location. For example, we're located here in Orange County. We usually, very rarely, will take a trusteeship that's outside of Orange County. We just know everybody here. Our network is here. Northern Trust, I think if you have properties in all different states or multinational, I think Northern Trust is almost a slam dunk if you have that kind of a situation. So location becomes really important. Does the trustee have the skills, you know, to handle your situation? Do the family members trust? Remember, they haven't lived together for 30 to 40 years. Do they trust? Do the in-laws trust? You know, is that when someone dies, does the property immediately go to the successor beneficiaries or to the beneficiaries?
In their mind, it does.
What is the normal routine when someone dies? Is there kind of a notice that has to be given?
Well, we've got, this is a good point. Here's a timeline that we can kind of talk about here. The first thing the trustee or successor trustee, let's say the person who created the trust has passed or the surviving spouse has passed. We now have stepped in and we've said, we've looked at everything. The successor trustee has made an educated decision to continue to step in and serve as successor trustee. The first thing they have to do is send a notice to the beneficiaries. And in this notice it will say, so-and-so passed away, I'm now going to serve as successor trustee. This is my address, this is my phone number. And by the way, here is a copy of the trust. You as the beneficiary should take a look at this and make sure that you understand it. Take it to an attorney if you need to.
And during that particular period of time, any one of the beneficiaries can protest the document, can protest the naming of a particular successor trustee. But do we do anything during this 120-day period?
No, you're basically making sure that everybody knows what's going on. And it used to be a problem. There was a time in California when we didn't have this notice. And we talked about the 3 kids where older brother was the successor trustee. He could effectively, at death, go in and take over the entire estate and make mistakes, spend the money, take trips, do whatever he wanted, and his sister probably wouldn't even know anything about that trust because it was a private document. So this notice to beneficiaries is a very important protection, and it only exists if the successor trustee uses it.
And if you don't hear anything, do you think everything is going well? No. And so communication, you know, besides having some business skills, make sure your successor trustee communicates with the rest of the beneficiaries.
What if you're contacted by a family member who is not a named beneficiary of the trust? Happens all the time. I've got the black sheep child who I've eliminated from my trust, and do I send them a notice? Better talk to the attorney about that, because there may be a reason to send that person a notice anyway, to let them know they should. I got to be careful here. It could be construed that they should receive notice and see that they are not in the trust and be able to have that out there. The people to whom are the natural beneficiaries can be sent this notice, but it is a very important conversation with the attorney as to which of those people you would actually send that notice to and which not. I guess you can imagine some of the situations both ways. But the question is, when you send them the notice, do they get a copy of the trust? Peter?
Yes. Okay, there was a family member who named their beneficiaries as the A beneficiaries received $50,000. The B beneficiary received $25,000. The C beneficiaries received $10,000. She was in here about 2 years ago. And she asked me afterwards, she said, will all my beneficiaries know if they were A, B, or C? And the answer is yes. She changed her trust. So everybody gets a copy of the trust who's an immediate family member and those individuals that are named in the document. Okay? And that goes for full disclosure. Yes? The question is, does the attorney who drafted the trust automatically do that when a person dies? And the answer is no. You can go to any attorney to do the trust administration. A little bit about the practicalities of the law. You do not have to go back to the same attorney who drafted your document. Today, probably every legal practice in Orange County, almost 40 to 60% of their practice is trust administration. So you can go to any estate planning attorney and they will assist you to administrate that estate. And yes?
Do you have to also notify contingent beneficiaries or just the...
If they're named in the document.
Oh, okay.
Okay? Every name in the document has to be notified that here's the trust and their name.
There's certain protections to sending people the notice. That can also create certain problems. But you want to look at what sorts of protections sending that notice to that beneficiary might assist.
It used to be private. Now was a gentleman that was in Laguna Hills by the name of Gunderson. And he did not send out notices of the trust. And it went all the way to the California Supreme Court and got settled. Whereas today, everybody receives notice of the trust.
Okay, he's saying, is a certified letter sufficient, or do you need a return acknowledgement? There's a statutory requirement for this notice, right down to the size of the font.
It's not something you want to do yourself. You want an attorney to draft it.
But
make sure it's done right.
Let's answer your question. Sending a letter certified return receipt is a very good idea, so that you acknowledge that they had, because that triggers a period of time under which they can contest the trust.
Major issue on AB trust, on the first spouse to die. Who usually gets named on the B trust as a successor trustee? Surviving spouse. Is there a little emotion going on there? Is there some issues there? Do immediately the survivor spouse go see the attorney and say, what do I need to do? No. We see so many AB trust scenarios where 10 years later there has been no separation of the assets. CPA has not been involved. An attorney has not been involved. If you have an AB trust, please talk to your spouse and say, get some help if one of us dies so that we can put it in the correct order. There needs to have some things done. So we see this really common. You need some skill to make sure that the assets are separated into the proper trust. Okay, we're going to hold off on the questions a little bit right now. Let's go through part of the outline. We're not going to get through the entire outline. The nice thing about the outline, though, it's very practically written. You can put it with your documents and someone can go through it themselves. If you have a question, there's an email for the both of us. There's a telephone number. As we like to say in this field, the attorneys draft the documents. we drive these documents. So we understand the practicalities and can answer those issues and questions for you, whether or not, again, you become a client of either Northern or myself. In distributing a particular estate, do you have any times problems understanding the value of particular items?
Oh gosh, yes. And you can err on the side of undervaluing or maybe sometimes overvaluing those assets.
Yeah, it's people who overestimate their household items. When you buy a couch from, let's see, from where?
Be nice.
And you want to put it on the curb to sell it the next day, what do you think it's going to be worth? You know, not much. Nowhere, even though it's brand new. Okay? When I see personal items being overvalued, is personal items ever an emotional issue?
Oh my goodness. Everything that happened to a family when they were kids in the sandbox comes up and rears its ugly head when it comes down to the simplest of personal property items. And what Peter said has a lot of value too, because not only do people get into disagreements over personal property, but as he said, personal property has very little value. So the last thing you want to see is trying to liquidate personal property for money. It's better to give it to people and then hopefully give it to the people in a way that's equitable. And trying to figure out if you've got a pair of earrings and I go in and I'm trying to find the ones that you've lent or that you want to go to your niece, and then I find that there's 5 sets of earrings, how do I know which one is the one for which party? Personal property can be an area where there's a lot of emotion. Yeah. And some value is always a question.
Yeah. Put a letter with your documents and say if you want to give away personal property to particular family members, and put a letter with your estate planning documents and say, hey, I wish the following to go to, and then you can list it. Now the problem sometimes is that when you write that letter and by the time you die, those personal items may not be there. So we've seen that as well. And personal items, I've seen $20 million estates. And what is the argument over? A small personal heirloom. And so it's, it's the big thing. Emotions are just running at a peak. Okay? It's kind of like when mom or dad dies, now I have permission to tell you exactly what I think of you.
Peter, tell me, so there's all sorts of personal property. What do you do to secure the property? What do you do with the residence, for instance?
Immediately upon death, we change locks. Okay? And we recommend you, as your successor trustee, do the same. Okay, if I had a painting on the wall here for 20 years, and if somebody removes it, do you think I will know whether or not there was a painting on that wall? Yes. Okay? It's quite common. Mom wanted me to have that painting. So the first thing we do is we change locks. What's the second thing that happens, Gary?
Mail. Things. Oh, we're going to talk about food in the refrigerator?
Well, then we can do that, but let's not go there. It's ugly. It's an ugly story. What about insurance?
That's a very important item. Be careful. Some sorts of property and casualty insurance is void after the home is vacant for more than 30 days. One of the most important functions, the primary function of a trustee, a successor trustee, is to preserve and protect the estate. That has a lot to do with making sure that the insurance coverage is both current and that the agents are aware of everything that's going on. Cars, boats, airplanes, real estate, all sorts of liability coverages. Get a hold of the agent, say, listen, just so-and-so passed away, we're taking over the house, we want to make sure the insurance is still in force. A lot of times people near end of death may have missed that notice for the premium payment. You want to make sure that that property is protected. Remember, the fiduciary has that obligation.
Yeah, and it's not to grow the estate, okay? If we have 200,000 shares of Apple stock on the date of death, what do you do with the Apple stock?
Well, I don't know. It's probably sell it, but you need to make a thoughtful decision on that discussion.
Yeah. So it's preserve, not grow the estate. Yes, you had a question.
What about rental properties?
The same thing applies. Preserve, not grow. So make sure that there's insurance on the rental property. Make sure that the property is safe. Make sure that the rents are collected.
Now, Mom and Dad passed away, and I just want to let you know, Peter, I stopped by the house and I picked up a few things today that were mine that were in the house.
I would ask you to return those things until the estate is settled.
But they were mine. They were sitting in the house there.
Until we have definite proof that they were yours, please return them to the house.
I was just there checking up on things, you know.
Did you not hear me? I used to do assertiveness training, and you have to become like a broken record. And because this is exactly what happened. And you keep repeating, but you need to return it. Yes, we understand, but please return it. Everything needs to, no distribution takes place until when?
Well, you've got to go through you've got to go through and make sure how much money you're going to need to pay taxes and handle the management of the property, and it may be a few months. It may be 9 months before you can do anything.
Yes.
What if you have judgment and creditors and all sorts of things? When you have a probate, you have a period that's public. You send out notices to everybody that conceivably that you know of, and even that you might not know about, the estate might owe that person money. You publish notice in the newspaper telling everybody possible that this person has died, and if you have a claim against this estate, you need to file that. What happens with a trust? No creditor claim period. It's a private document. If you think that you might want to exercise the creditor claim period under a trust, you can do so.
Are you saying the judgment enters in, now you put that in your living trust?
Well, it doesn't enter in, but you need to let everybody know, because if you don't let everybody know that this is happening and that you're distributing all the money out of this estate, that judgment will follow those beneficiaries.
Or
and they'll go after them.
After the trustee, your successor trustee, for payment. Mom lends money to son to start a business, $50,000. Does mom want son to repay that debt upon her death?
It was a gift. It wasn't a loan. It was a gift. Mom just said it was a loan, but she didn't really mean it. It was just a gift. I don't have to pay it back.
I have two other kids in the family to say that it was definitely a loan. It wasn't a gift at all.
I never liked them anyway.
As soon as you lend money to one of your kids, every other child will know that you lent money to them. It's especially family radar that immediately everybody knows. Okay? What the problem is, though, is that nobody puts a document with the estate planning documents either indicating the loan is forgiven on my death or the loan needs to be repaid. Please, if you lend money to somebody, please make a note and put it with your documents. Another thing. Are any of these documents fun to read upon a death? No. No. Does any of these documents contain the word love? No. In fact, it's discouraged. Okay? Put a letter with your documents and say at least twice in that letter the word love. Okay? It has nothing to do with legalese. When someone dies, it is a highly emotional situation. And so if they have a personal letter from you indicating how you feel about them, if it's positive, please include it with the documents. It goes a long way in soothing some of the ruffled feathers in doing your estate plan. It's something personal.
It should not be legally binding.
No.
It should be an expression of your wishes and desires and feelings. In the business, we call that precatory language. It is something to help understand the thinking and feelings of the person who created that letter, but is no way intended to supersede any of the legal binding documents.
If even especially, let's say if you have a spendthrift son or daughter, state in the letter, I didn't give you the principal because you are a spendthrift. They know they are spendthrifts. Okay? And at the same time, you can state in there, even though you're a spendthrift, I still love you. That has nothing to do with it. But for this particular purpose, I have extended income over your lifetime. And that is an adult way to handle things. What happens a lot is moms and dads get afraid of the children and don't want to tell them anything. Please put a letter together. I'm going to go start on page 2. We've got a good 25 minutes, so let's go through it. Does each one of you have a list of the family members that you want to have notified? Do you have friends that you want to have notified upon your death? If you don't, put one together. It would be of an immense help. You go through Christmas cards and try to figure out names and addresses?
Oh gosh, yes, and address books and everything else.
Yeah, so if you have a list for yourself, it would be wonderful. The emotional impact when someone dies. What's the kind of the average state of shock people are in after a death?
Yeah, and that's one of and that's the situation. You want to make sure that certain people have the time to reflect and to go through their grieving process, and don't burden them with a lot of financial other obligations they have to deal with at that time. There are certain deadlines and timelines that occur after death. And
if you want the entire family to be flown to Arlington Cemetery, to be put up at the Mayflower, and to be flown back at your expense, please state that in your trust. Or something that says, this is what I would like. I want doves to fly out of the coffin at the funeral. Okay? I want a parking meter that says expired on my grave. Whatever you want, you can have, but put it in writing. Let's see. We talked a little bit about security at the decedent's house. We talked a little bit about perishable property. Some people like animals more than humans.
Everybody raise their hand?
Okay, there's a lot of things that you can do if you like your animals as far as giving it over to someone else to care for. They have pet trusts today, etc. So make sure that you take care of that beforehand. Who takes care of the funeral arrangements?
Well, it could be somebody that is holding, well, the advanced health care, well, you're talking about the advanced healthcare directive agent can handle that.
And then who pays?
The trustee.
So they better get along, huh?
And where do I find, what if I want to keep those safe, do I put those in my safe deposit box?
Please don't put your legal documents in your safety deposit box.
Wait. Not any legal document?
No, not any. I don't think any.
Your original documents?
I don't think so. I would put them in the house, keep them with the attorney. I don't think you're going to get a burglar to come into the house and say, let me find that estate planning document.
Oh, what if the house burns down?
The house burns down, make sure you have a copy someplace else.
Okay, I would suggest the original be in the safe deposit box and copies be in the house.
Safety deposit boxes are sometimes a real problem. If I go into the safety deposit box, is there anyone with me when I go in? I don't have to, but I always will. I always take 4 set of eyes on whatever we open up to see what's in there. Because what happens if Mom said in her agreement, I have the Blue Hope diamond ring, $30,000 in my safety deposit box.
Hey, I went and looked and it wasn't there.
And it wasn't there. I call them up. I'm sorry, no diamond ring. What, are they going to believe me? No. Okay? So safety deposit boxes are kind of a trap. So be careful. You can name your stock certificates, your bonds. Keep them in a discount brokerage. It's much safer. You don't have to worry about fire, etc.
Anybody still have any stock certificates or bearer bonds?
Yeah, keep it in the street name with a brokerage firm. It's a lot safer.
What if it's a private company?
What's that?
What if it's a private company?
Then you've hit the one situation where we can't. Yeah, they're not DTC eligible.
Yeah, but you hit a very good point. When we stand up here and talk, we're talking about generalities. Okay? It may not apply to every single particular situation that you have. And so thank you for that comment. It's perfect. Gary, is there a place in the, that you can possibly locate items as to their, besides the house?
Yeah, what about, has anyone ever found escheated assets on the internet? What? Escheated assets, is that a new term? Yeah. Ah, interesting. So if you were back in high school, when you opened up your first bank account, and then your folks moved away and you forgot about that bank account, guess where that bank account went? To the state. That is called an escheated asset. And it could contain all sorts of things. I have a client right now where we found about $750,000 worth of missing assets. And every time I thought I had them all, something else popped up. You can go on the internet.
Yes. In fact, Gary put an article out on the table about finding unclaimed property.
Unclaimed property. It's the state controller's office. There's actually a website there that claims to capture all of the states. I've tested it and it didn't quite work. So the idea is to go to every state. It's kind of a fun exercise. You can pick on your neighbors. You can go to your kids. I found assets for all sorts of people that I basically said, here, you guys got to go claim this money.
And it's called unclaimed property. Google it. Every state has usually a site, and it's exactly right. I always find people that I know. I put my friends in as far as their names are concerned. Give them a call and say, hey, you've got some assets that are with the state of California, and you just follow the directions and you can claim that property.
Let me bring up another issue, as though most of the assets we recently found were dividend reinvestment plans. They're known as DRIP accounts, where somebody has gone to IBM and started an account with IBM where they actually take the dividends on a particular holding of that IBM stock, and the dividends are reinvested in additional shares, called dividend reinvestment plan. And companies will host those sorts of programs for people who want to be investors in that company. And in this case, we'd found a mom who had created DRIP accounts all over the place, and we had to go through transfer agents to find all of those DRIP accounts. Another area. And DRIP accounts can also be an area where you don't get a regular statement necessarily. You may get the 1099 with the tax information, but that's another place where you can find missing assets.
How many tax returns need to be filed in the first year of death?
Well, okay, so we've got the 1040, 540. That's an easy one. There's the first two. Now, once the trust becomes irrevocable, meaning once the person dies and their wishes become cast in stone, that then becomes an administrative trust. An irrevocable trust is created as an administrative trust after the death of an individual. That will trigger a separate tax return, because that is a separate tax, the trust then becomes a separate tax-paying entity, and it's required to be filed a 1041 versus a 1040 or a 541 versus the 540. There's also other sorts of notices that are required in regards to the return.
Yeah, so you basically have 4 tax returns that you need to file. Hire the appropriate CPA who has some fiduciary tax return experience.
He asked what happens to the property taxes when you get a basis step-up at death. The property taxes will depend on who the beneficiary is to that property. The property taxes will not change strictly based on the step-up in basis, but if it goes to children or grandchildren, there are certain exemptions where you can maintain the current property tax basis for purposes of that transfer.
Do you have to take some steps, or is that automatic?
Great question. There is a requirement that those, and I can't recall the exact parameters, but if you don't file that...
6 months.
Is it 6 months? If you don't file that within 6 months, you jeopardize that as well as have certain penalties. So that's another one of the checklist items a successor trustee needs to be aware of, is to file for that, particularly when it's going to transfer to family members and can be, and that property tax basis can be preserved.
We hire attorneys upon someone's death. Just a notification that needs to go out on 120-day notice with the trust, that letter needs to have a certain font size in order to be legal. That's how particular they are. Everybody needs to get notification. The tax returns, the Prop 13 issues. Is appraisals ever an issue?
Oh gosh. Yeah, there's certain situations where you may hope for the lowest possible value for the property. There may be some where you are not as concerned about getting a low appraisal. So yeah, appraisals are very key in tax planning.
Yes, and there's a certified appraisal out there, and you got to hire the appropriate individual, whether you're talking about paintings, whether you're talking about artwork, whether you're talking about real estate. This is not the time to go cheap, okay? This is the time to hire the good professionals, because is every 706 return audited?
I would say pretty much they are. And in fact, most situations I say to the IRS, give it your best shot, because we don't want to wait around for 3 years to get a statute release.
Yes. So you'd want to make sure you do it right. And the revenue agent on the IRS side earns about $5,000 in taxes per hour. So people who don't do it right, and they don't check off the appropriate box, this is not amateur hour when you get into a larger estate.
What's the 706?
Oh, I'm sorry, we're using jargon, and thank you. The federal estate tax return where you report your estate is called a IRS Form 706. And it is the 706 represents a snapshot in time. And it can be the date of death, or it could be an alternate value 6 months after, but it represents a snapshot of everything that decedent owned as of that point in time. And so it's going to have a value.
Is there a minimum on that?
On the 706, there are, well, for the next 2 years, there are certain situations where you may decide to file an estate tax return even if the estate is less than the $5 million that we have for the next couple of years, just because you want to memorialize certain things, or you've taken certain discounts and you want that to be a matter of record. But typically it's $5 million or $10 million for a couple.
How many death certs should a trustee or successor trustee get?
Question for the group. How many people have ordered death certificates and found out they ran out?
Get enough.
Yeah.
Okay. I would say 12, depending, or 15, depending on the financial institutions. Every financial institution wants to see a death cert.
An original, not a photocopy.
Not a photocopy.
So they have to be a certified copy.
Yes. Let's see. Obtain evaluations. We talked about that. final tax return, estate tax return. On number 38, we have it in bold. Keep the beneficiaries informed regardless of legal duty to do so. What do you mean by that?
Well, Peter, you said that earlier. Here it is. I'm successor trustee for my parents' trust. Everything's just going really smooth. I'm just happy at this because one of the things that Peter didn't put on here was time. I don't have time. I don't have time to be babysitting a bunch of beneficiaries, particularly if everything's running smooth. I'll let them know when there's something to tell them. Right now, everything's just working out great. Okay? What's my sister think? What's going on? And I never did trust your brother. He's saying, listen, I haven't heard a thing from anybody. That means that there's something wrong. So the idea of keeping beneficiaries informed is really a smart idea in the long run. It builds a lot of trust and confidence in what they're doing.
What's the most common question you get from a beneficiary?
When? That's right. And how much? Okay.
It is a legal technical term, pillow talk. What does that mean?
Why is your brother holding out on us? Why isn't he giving us the money that's ours?
Okay, lots of that going on. Okay, and it may not be your son or daughter. It may be an in-law that basically says, "How do you know your family is trustworthy?"
Did you ever get a phone call from the car dealership or the real estate escrow company?
Oh yeah, many a time the beneficiaries have your money spent before you're even cold. Okay, and so you get calls from the dealership, you get calls from the escrow, you get calls from the loan company verifying that the assets are there and so that they can get a loan. So, you know, it happens much more often than you like to think. Now remember, we're kind of like the cops who, you know, deal with the bad folks sometimes. They don't name most people don't name a private fiduciary or a corporate for the good reasons. A lot of times it's just because there's a major problem within the family. So sometimes we tend to be, at least I do, a little bit cynical sometimes about the situation. But I want to go back to what we said in front, and it said most trusts, most estate plans go very orderly and there is not a problem. The issue is that we have about, what, 3.5 million people here in Orange County. So even when we have a small percentage, that is a lot of problems that are out there. So please choose your successor trustee. By the way, how many individuals ought you name as, for example, in a will? We named down 3, but is there a rule that says that you have to do 3?
No, and really what you want to do is have a backstop. So whatever number you pick, you should at least have somebody at the very end who you know is kind of a fail-safe, and sometimes that becomes a private fiduciary or a corporate fiduciary. You may have business manager number 1, you may have child number 2, you may have another child here, but eventually these people may step may decline to act because they don't have the time, they don't have the expertise, whatever other reasons are legitimate, and you need somebody kind of as a backup. Say, what's going to happen if all these people don't decide to take this on? What are you going to do here? Do you really want them to have to go to court to pick the last one?
One of the things that you may want to look in your documents and take a look in there to see whether or not the successor trustee that you have named has the power to appoint a successor trustee. So let's say, for instance, you name John as your successor trustee. Does John have the right to name a successor? It's called a power of appointment. We recommend it, we like it. It's just that to prevent from having to go to court in the event maybe the successor to John doesn't want to serve.
There may be situations, though, where you like John and you think he would make a fine successor trustee, but you don't necessarily want to give him that power to pick his successor. You trust him, but you worry about what might happen. So you kind of have to weigh that out.
Do the beneficiaries have any power over the trustee?
We talked about that earlier. The power to remove the trustee, making a trust portable, is very important. But you want to have some restrictions on that. You don't want them trustees shopping every time somebody tells them no. So you may put certain criteria, such as they can't change trustees more than once every 5 years. Or if you're working with a corporate trustee, they have to be a corporate trustee of a certain size. Also, you'll want to say that it has to be a majority of the competent adult beneficiaries who have to come together and make that decision.
On page 3, right in the center, it says general trustee duties, specific duties, loyalty. What does loyalty mean?
Means you have one allegiance, and that is to that trust and those beneficiaries. You have to do everything with the thought in mind that this is for their best interest.
So mom has a car, that Mercedes. I knew she wouldn't mind me driving it while we try to figure it out. Can I do that?
Heavens no.
Okay.
Let me try this one, Peter. When Dad, let me put it this way. When Dad, or two ways. When Dad was alive, he was a very smart businessman. He invested our money in some very good investments that not everybody would have invested in. They were a little bit risky, but Dad was really smart. I'm going to invest the money the same way Dad did.
I would say wrong answer. Okay? What is the duty of a successor trustee? Is to preserve, not to grow. If the beneficiaries want to follow Dad's way of investing, then they'll wait until they get the dollars, and then they can invest according to the way Dad wanted it to.
Okay.
On the other hand, if Dad said in writing to the trustee, I want you to do blah, 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 then the successor trustee can hide behind that the trustor's directions and follow through on that.
Okay, well, then I'll tell you what. Then I'll just invest. I invest my money a certain way, and it's pretty smart. It's pretty conservative and pretty prudent, but I take a few risks. I'll just go ahead and invest the trust money the same way I invest my own money.
Wrong answer. Okay? Wrong answer. Again, it's to preserve.
I can't get anything right around here.
That the idea is to preserve. Money market funds, CDs. We don't invest in, if you have a trust, let's say, that goes out for a minor child, and for 20 years, now we can invest in the stock market, put a balanced portfolio together, etc. But when we're talking about an administrative or a distribution trust, we want that money absolutely to be safe.